comes great responsibility.
So they tell me. Oh.
Great responsibility.
So they tell me. Why is it?
Great responsibility.
Professor, thank you for coming.
Professor,
Okay, I'm glad to be here. I wanted to get early to get a good seat here. Actually, I wanted to see how I share the screen again. I haven't done
Yeah,
this.
let me add you as a host, and then it should pop up as an option. All right, now you should have the option down at the bottom of your
Well,
screen.
let's see if it works. Let's see. Ah. Oh. Let's see. You see it?
Yes, I do.
Okay, then I'll stop sharing.
Wouldn't want to give too many spoilers.
Yeah, except now I got to figure out how to stop sharing.
think there's something at the bottom of your
Oh,
screen.
whoa, whoa, I got it.
Okay, good. Oh no, it's at the top. I don't know.
No. I got new share. I don't get stop share. Huh. Phew. Why is this so challenging?
Here, I think I can stop it for you, maybe. There we go.
Okay, well then maybe you should be in charge of stopping it.
You can be in charge of starting it, and I'll be in charge of stopping it. Sounds good.
Yep. Very good, very good.
That's giving Josiah a fair amount of responsibility, Professor.
I think I can pull it off.
Professor, we're really, grateful for you joining us tonight. We really appreciate this.
Well, normally I'd say, oh, it's nothing, but it turns out it's a lot of work sort of preparing. Well, I mean, plus his article is 80 pages long.
I started reading it and I got about 15 pages in and then realized, like, wait a minute. If I read this instead of my Fed courts reading, Professor Gardner is not going to accept. Well, I was reading about Pennoyer as a good excuse for a cold call gone awry.
Well, it turns out I'm not sure it needed all those pages. Okay, I got this figured out.
Professor, when I do your introduction, do you want me to just use your faculty bio from the webpage, or do you have a different one you'd like me to use?
Oh, the faculty bio would suffice, although I don't think you have to go into much detail. Won't most of the audience know who I am?
I suspect so. So maybe I'll give the abbreviated version.
Okay.
Oh my God.
You got a laugh there for that one. I always slouch when I'm doing these. Do I look intelligent?
Happens with that means a lot of US people's data activities can easily be monitored by the Chinese government as a fear that US government has considered as possible concerns. So for personal data issues are quite important these days.
Professor Sachs, thank you for joining us.
Thank you for having me.
We'll get started in a couple minutes. We had a lot of people signing up for this one, so or RSVPing rather for this one. So I'm sure they'll be joining in the next couple of moments. Just gonna give it 1 or 2 more minutes if that's all right. People are pouring in pretty rapidly, it looks like. All right, we're going to go ahead and get started. Thank you, everyone, for joining our event on whether Pennoyer versus Neff was right. I am sure that when Sylvester Pennoyer, John Mitchell, and Marcus Neff were disputing the ownership of the property near Portland, Oregon, they had no idea that their doing so would haunt the dreams and cause many a sleepless night for law students for a century and a half or so. But it did, and that's why we're here, is to hear from two extremely distinguished scholars on the subject of whether Pennoyer was right. I'm Josiah Rutledge. I am a vice president of speakers for the Cornell Federalist Society. I am very, very delighted to be hosting today's event. I will do our speaker introductions in just a moment, but first our chapter president, Nitin, has an announcement.
Good evening, everyone. Thank you so much for joining us tonight. We're really excited to see such strong turnout and so many new faces. Before I turn things back to Josiah, who will get things started, I know many of you have asked me about DoorDash for tonight's event. DoorDash will be sent out towards the end of tonight's program. And since there are many of you here, I'm probably going to need to use a random number generator. But priority will be given to those of you who turn your cameras on. So if you all can do so, that would be much appreciated. Take it from here, Josiah.
All right, thank you, Nitin. So let's jump right into introductions. So going first will be Professor Stephen E. Sachs, who is the Antonin Scalia Professor of Law at Harvard Law School, where he teaches civil procedure, conflict of laws, and seminars on constitutional law. His research focuses on the law and theory of constitutional interpretation, the jurisdiction of state and federal courts, the history of procedure and private law, and the role of the general common law in the US legal system. Sachs previously taught at Duke University School of Law and as a visiting professor at the University of Chicago Law School. Before entering academia, he practiced in the Washington, D.C. litigation group of Mayor Brown, and he clerked for Chief Justice John Roberts, as well as for Judge Stephen F. Williams of the U.S. Court of Appeals for the D.C. Circuit. And most relevantly, the reason we have him here speaking to us is he published an article a couple of years ago, I believe now, on whether Pennoyer was right, and he'll be presenting based largely on that article. And our second speaker, for most of you, needs no introduction, the inimitable Kevin Clermont, who is a specialist in the procedural aspects of litigation and a foremost expert on just about every aspect of procedure. He is a graduate of Harvard Law School, and after which he clerked for the Southern District of New York, spent 2 years in private practice as an associate at Cleary Gottlieb, and joined the Cornell Law School faculty in 1974, where, among other things, he has had the immense misfortune of having to teach me personal jurisdiction, or as he would have me say, territorial jurisdiction. The format for the event will be 20 minutes for Professor Sachs, 20 minutes for Professor Clermont, 5 minutes for Professor Sachs to respond, 5 minutes for Professor Clermont to respond, and then Q&A from our audience. So be sure to be thinking of your questions. And without further ado, I'll turn it over to Professor Sachs. Thank you, everyone.
Thank you very much. Give me one moment to share my screen and I can appear as a accompaniment to some slides. So I think that should now be visible to you. So I very much appreciate the invitation, the opportunity to speak, and Professor Clermont's being willing to comment and respond. My position is that Pennoyer was right, and I'll try and explain why in the next 15, 20 minutes or so. So the modern doctrine of personal jurisdiction takes the following form. Personal jurisdiction is a doctrine in constitutional law. It comes from the 14th Amendment Due Process Clause. Its source is traditional notions of fair play and substantial justice, and it is to be enforced in state and federal courts in precisely the same way. This was not the way that things were thought of at the founding. At the founding, the original doctrine was that there were no constitutional limits on state jurisdiction. Nothing in the original Constitution says anything about it. The source of authority for jurisdictional doctrines was general law, that body of trans-jurisdictional unwritten law that included the English common law, principles of equity, rules of admiralty, international law, and that in particular was relevant to questions of personal jurisdiction. It was primarily territorial in application. It mattered where, which sovereign had jurisdiction over which territory. And it was primarily enforced via recognition. So if you had a judgment from another state, would it be recognized, or would they say, no, sorry, that exceeded the rendering court's personal jurisdiction? What the 14th Amendment and Pennoyer did to that original doctrine was to federalize it rather than constitutionalize it. So post 14th Amendment, you cannot have a deprivation without due process. And if a court renders a judgment without jurisdiction, whatever kind it is, well, that's not really a lawful judgment. And so it's not really due process of law. That meant that the source of the underlying doctrine stayed the same after Pennoyer. These were still doctrines drawn from general law. It was just that now they could be enforced in federal court as a matter of due process. So it remained equally territorial, and it would be enforced via federal question jurisdiction and appellate review, rather than through recognition actions in a later suit. So again, the 14th Amendment did not constitutionalize personal jurisdiction. The rules of personal jurisdiction are not found by staring harder at the due process clause until it finally reveals its secrets. What it says is that federal courts now can review what the states are doing in a way that they could not before. So let's see how this worked. At the founding, here's the United States in 1790. The Constitution was there to unite a whole bunch of disparate states, but it had no rules for personal jurisdiction. It didn't say anything about where the states could govern. But in the same way, the Constitution also didn't say anything about state borders. It didn't say how far each state's power went. And when there were territorial conflicts, here we have the dispute over the Toledo Strip between the Michigan Territory and the state of Ohio that came to blows at various points, and you had the Toledo War. There was nothing in the Constitution that could answer the question, what state is the Toledo Strip part of? Instead, those kinds of questions had to be answered by other law. Well, it wasn't going to be state law. Ohio couldn't just say, we own it, or New Jersey couldn't just declare, we own Toledo. And it wasn't federal law because Congress hadn't said anything. So it had to be some other source of law, which I argue was general law. So here's a map of how folks might have thought of these questions. So you have the US Constitution, federal statutes and treaties. You have state constitutions, state treaty statutes, state customs and usages. And underlying all of those were doctrines of general law, which might be incorporated by reference by a state as a matter of state law. So it might be that rules about common law burglary or something were also North Carolina law, but they were at the same time general law that could be used by any state. And federal courts could use general law too. So here I have the Swiss cheese model of general law. If you have a question that's answered by the Constitution, great. If it falls through the holes, the Constitution doesn't say anything, but is answered as a matter of statute, also great. But if it's not answered by statute and has to be answered by some state's law, well, fine. But what if it falls between the cracks between any two states, such that no one state's law can answer the question and nothing in federal law speaks to it? In that case, it might have to fall all the way down to the general law and be answered there. That's how the courts typically handled state borders questions. And it's also how they handled questions of what a state could do within its borders, what kind of personal jurisdiction or territorial jurisdiction it could exercise. So let's think about how this works. Suppose that this were a court from Canada, international judgment, and it rendered some judgment. Now you've got your nice Canadian judgment with a shiny seal on it. Well, what would a court in North Carolina make of that? What would they say? Would it have force in North Carolina? Well, one question they might ask in the process of answering that is whether the Canadian court had personal jurisdiction over the defendant, could order them around. And if it didn't have jurisdiction, if it didn't have authority in our eyes to order them around, well, then that's not really a judgment. That's not something that has lawful force over the defendant. And so we would say, no dice, we're not going to enforce it. The same thing might occur within the United States through doctrines of allegiance. The way that we figured out whether a court could boss you around was based on principles of who you had to obey. So if you think about an ordinary car crash, question, was the light green or red? We could have a scientific inquiry commission descend to answer this question, and they could use lots of science and deliver a report. Another way we can answer this question is by getting a group of 12 randos from this phone book and then having them calling them a jury and having them render a judgment. Now, the problem with that, obviously, is that the jury doesn't know anything compared to the scientific commission. But according to the law, the jury's judgment is binding, and the Scientific Inquiries Commission might not even be admissible evidence if you don't have testimony. So the legal system decides these questions not because it's the most accurate, but because we can order you to obey what the jury decided, even if the jury might get it wrong. Jurisdiction is the power to get it wrong and to be listened to anyway. So if we think about how this works, when can we boss you around? When can we get it wrong and expect to be listened to? Well, there might be categories of permanent allegiance, like citizenship or residence. In those cases, you always have to obey what your government tells you. And if you're out of the jurisdiction, you might have to obey a statute that says, come back when we call you. But there might also be forms of temporary allegiance for states other than your own. So if you're in the jurisdiction or have property in the jurisdiction, they can boss you around. You have to obey them while you're there. And if they serve process on you, you're obviously there at the time of suit. Or you might voluntarily appear or consent. In that case, it doesn't expand the power of the court. It just avoids the need to ask the question whether the court can force you to show up. On this model, if we think about it for corporations, there might be other sources of authority. So the state of incorporation is what gives you the special permission to act as a corporation, and they might require that you appoint an agent. The state doesn't have to recognize foreign corporations, foreign entities. You can't go into court and say you represent the Corleone family. They'll say, well, that's not a thing according to our law. It's not an actual entity. So other states would say, look, if it's not our entity, then we might say you have to give explicit consent. So you don't get to show up here as an entity in court unless you take out a license, appoint an agent for service of process, and so on. Or we might let you operate here as a corporation implicitly by comity. And if so, if you do things that require corporate existence, we're going to say you have to admit to our jurisdiction. So if you're doing business here, holding property, entering contracts, appointing agents, if you're doing things that require you to exist as a corporation, in that case, you have to obey when the jurisdiction orders you around. In international shoe, this kind of test was expanded to become what we now know of as minimum contacts. But that's not how they thought about it back then. They thought about it as you're doing things that require you to exist so you can exist for purposes of jurisdiction too. So let's turn back to our example of a judgment from one state that might have to be enforced in another. So we say we have judgment from North Carolina. Now we're going to be in federal court. If there's diversity and sort of a route into federal court, then the federal court can hear this case and it can say, well, what are we going to do? Are we going to enforce this judgment or not? And so we might ask, do they have jurisdiction according to all of our general law rules? And if they don't, then we won't enforce it, just like as if it were a judgment from Canada. Now, if, though, the North Carolina court issues a judgment and we can't get into federal court under diversity, there's really nothing else that can happen. The North Carolina court, if they can grab you and they can take your stuff, there's no federal review because there's no Article 3 jurisdiction. There's no federal question here. So every state was able to exercise jurisdiction that under the general law, they probably shouldn't have, so long as they could grab your money and do other things in state. There would be no federal review of that judgment and no reason why another state had to weigh in. So now we can see the example of Mitchell versus Neff. Here we have the summons ordering Mr. Neff to show up. We had a judgment from the Court of Oregon in Mitchell versus Neff. Then Neff comes back, discovers that his land has been seized, goes to a federal court under diversity, and then the federal court is going to ask in Neff versus Pennoyer, was there jurisdiction in Oregon to do this? And as we know, they concluded that there was not, and so it's not a real judgment, and so we don't have to enforce it. But what's interesting is that in the meantime, after all of the Mitchell versus Neff stuff had happened, the 14th Amendment had been passed. And what the court says in Pennoyer is that since the adoption of the 14th Amendment, those judgments could be directly questioned and their enforcement in the state resisted on the grounds that proceedings in a court of justice determine the personal rights of obligations of parties over whom that court has no jurisdiction do not constitute due process of law. In particular, it wasn't saying that the rules of jurisdiction are sort of hiding in the due process clause. What it was saying is that for a judgment to be valid, the court has to have jurisdiction. That includes subject matter jurisdiction and personal jurisdiction. Now, Pennoyer v. Neff is normally not thought of as a case about the subject matter jurisdiction of courts, because the subject matter jurisdiction of courts isn't something that federal courts think about much. When we're trying to figure out what to do with a state judgment, whether it has subject matter jurisdiction, we'll typically defer to state law. That's a state law question. So, it's essentially an adequate and independent state ground if they say it does. But if it's a personal jurisdiction question that we have to answer, well, that we don't defer to, because it's not just a question of state law, it's also a question of general law, what the states can do outside their own borders. That's not a question that each state gets to answer according to its own law. It's a question that the federal court has to take an independent view of. And if, according to that general law, it's no good, then the federal court will not enforce it. In particular, the effect of the 14th Amendment meant that what before the amendment was a case that you couldn't get jurisdiction of if there was no diversity, now you could get jurisdiction, because you would say, look, if even in a non-diverse case, we can say that there's a federal question here. There's a threat to deprive someone of property, arguably without due process of law. And so the court should not have issued that judgment if the enforcement would violate the 14th Amendment. And that means the federal court gets a route to review in every case, even between non-diverse parties. And so the upshot, as other courts noted at the time, is that any case involving personal jurisdiction is going to go to the Supreme Court. They're going to get a view of it. And once it gets there, it's not going to do whatever the state court said, but rather it's going to follow its own understanding of the general law rules as announced in previous cases and in Pennoyer. And so the state courts better straighten up and fly right if they're going to avoid getting reversed on appeal. And so even if this issue, the substance of it is not provided in federal law, it's not that the due process clause says in state service and citizenship and residence and stuff like that. It's just a general law principle. But because the Supreme Court is going to have review, we'd better do what they say. Now, this produces sort of Rube Goldberg kind of setup. A judgment lacks personal jurisdiction under general law, means it's going to lack personal jurisdiction in the eyes of the federal courts, meaning that on review, they're going to hold that it violates due process, meaning that the state judgment is going to be reversed, meaning that we should avoid doing that by invalidating it now. Over time, this just becomes a question, does it violate due process? And that's very easy to see why we would ask it that way. That's how International Shoe thinks of it, but it's not really the right question. And that explains how our law of jurisdiction has gone so wrong. Now, this has some implications for the political branches. If these are questions that fall into the general law only because no federal statute answers them, then it might well be that Congress would have authority to answer them under the full faith and credit clause, which says that it can prescribe the effect of state judgments. In doing so, it can override the general law. So Congress could, by statute, say when courts can and can't have personal jurisdiction. Moreover, for federal courts, under the horizontal necessary and proper clause, they can say when the federal courts can exercise jurisdiction, even over foreign defendants. So in Pickett versus Swan, 1828, they said that Congress could, if it wanted to, call people from England and France and Russia. That's just up to Congress. That's not something the federal court's going to get in the way of. And so under this rule, the Fifth Amendment due process clause only requires some source of jurisdiction. It doesn't contain all of the general law as if it's an invisible ink. Just as you've got to have some source of jurisdiction. And if Congress can provide it, then it can provide it for federal courts across the globe. Finally, if the federal courts were going to adopt if the President and Senate were going to adopt treaties, that too would be a source of law overriding the general law that would enable them to specify jurisdiction. Last point I want to make is what are courts supposed to do about this before Congress speaks? Well, right now, instead of thinking about it as a question of constitutional law, they ought to think about it as a question of general and international law. That lowers the temperature of the debate. It means that courts are finding provisional answers, not permanent ones. They're finding answers that Congress can, in fact, reverse. And it should look at actual practice, not at abstractions like, minimum contacts or fair and reasonable. We're not looking for the best theory of individual liberty, as was going on in Nicastro. Instead, we're asking what is required by our domestic traditions or by international law. Now, that could change over time. General law doesn't have to be the same in 1878, 1945, and today. But international shoe and its progeny weren't really about general law. So it might well be that the general law was sort of left alone, the way that we would say at common law, burglary had to be at night, even though no jurisdiction currently does that, because no jurisdiction does that by statute, sort of left the general law in place. So I think that's where I'll stop. I look forward to your questions, and in particular to Professor Clermont's response. And thank you very much for your time.
Thank you, Professor Sachs. Professor Clermont, hopefully you still have your screen sharing capability, and turn it over to you.
Okay, I'm having a little problem getting this onto the screen here, so hang on.
If it ends up being too much trouble, you can send it to me and I can share it on my end, hopefully.
That you can't see, I assume.
Oh, this I can.
Okay, very good. Okay, so I want to start with a little local knowledge of which Cornellians have plenty. Pennoyer was born in the next town over, on Main Street in Groton, New York. And here's a historical marker showing the birthplace. And you'll notice that he's called Slyvester Pennoyer there on the historical marker. That's not very flattering, but it's more flattering. He was known by the trial judge in Pennoyer versus Neff as Slypester Annoyer. So it's a bit of an improvement. Okay, I think to discuss this, I have to begin by distilling. Professor Sachs thinks this is what was right in Pennoyer, that the new due process clause requires only territorial jurisdiction, full stop, as Professor Sachs likes to say, and that the content of the requirement came from general law. Now, what general law is the unwritten law that forms the basis of our legal system, which courts find rather than make. And a key factor was that one sovereign's view of the general law did not bind other sovereigns. And Professor Sachs says that effectively federalized the general law. And he uses the rather questionable hook here of relying on federal appeal based on due process's requirement of jurisdiction and on the state court's fear of being reversed based on their general law. So we would end up with federal view of general law prevailing throughout the nation. Now, he makes the point that the advantages of his view are that legislatures and and treaty makers can reform the general law. And moreover, this approach would somehow miraculously induce the state courts, induce all the courts to better behave when they're shaping the law of territorial jurisdiction. Now, I'm still having trouble here, but you can hear me, I assume.
Yes, we can.
Okay, but I don't know why I can't see my screen. Okay, so I want to question both halves of his title. Is his proposed approach right? And is it Pennoyer? And I think neither is correct. Is this view a desirable view? Is it the right way to approach personal jurisdiction? Well, you know, one of the advantages that Congress and the states can legislate on personal jurisdiction. Well, don't ignore the fact that under our current system, Congress has extensive power under the full faith and credit clause and its commerce and foreign relations powers to codify, contract, even stretch slightly our jurisdictional law, and the state legislatures can do that too. So the only effect of Sachs's view is to authorize statutes and treaties that we view as fundamentally unfair. For example, as Professor Sachs says in another article, Congress could authorize global jurisdiction. And I might add that the Supreme Court denied cert today in a case that posed the question of whether or not we really do have global jurisdiction. Even assuming political will on the behalf of our legislatures, is what we really want to authorize that Congress and state legislatures can do anything, whether it's fundamentally unfair or not? I mean, do we really want to become French here? The French say that you can have, the French courts can hear any case occurring anywhere in the world. In France, you can hear it in France if the plaintiff is French. That's Article 14 of the Civil Code in France. Do we want, under our Constitution, to enable the Congress to do that? That would be the change here, that the Congress and state legislatures would have the power to do something fundamentally unfair. As to the improvement that, for the courts, that they would suddenly improve on their 145 years of miserable performance on making up the law of territorial jurisdiction, merely because we tell them, oh, well, you're not construing the Constitution anymore, you're construing something subconstitutional, does seem a bit of a pipe dream. That deciding by general law and by refocusing on sovereignty, those won't make the hard problems disappear or improve decision-making, especially given the non-existence of general law today and the inevitably increased role for judicial discretion under the Sachs view. Now, okay, so I'm not thrilled by where we would end up under the Sachs view, but I also think this is not what Pennoyer said. What Pennoyer did was it took the peculiar theory of a 17th century Dutch theorist named Ulrich Huber and declared that to be the general law. He stressed, Huber stressed the territorially bounded authority, exclusive power over persons and things within the borders of the sovereign. That was Field's view of the general law. Second, Justice Field went on to say, that's how we're going to read due process. Indeed, you know, I mean, after all, Justice Field was a good source for looking at the original meaning of the 14th Amendment, since he was writing in 1878 on a amendment that was promulgated in 1868. But in he writes one paragraph where he says how this is going to apply on the due process. And in that paragraph ends by him saying, due process means that a defendant, quote, must be brought within the court's jurisdiction by service of process within the state or his voluntary appearance. In other words, he's putting content, definition into the due process clause, not merely some abstract requirement of undefined jurisdiction. Third point would be, you know, the rules of personal jurisdiction, territorial jurisdiction are within due process. Since Pennoyer, there have been 145 years of court cases that have read Pennoyer to be talking about due process, the requirements within due process. And so, although, Justice Field, by federalizing the general law, bound the states to follow the federal dictates under the Supremacy Clause. Fourth point, is that he had to do that. This is something that Professor Sachs, I think, overlooks, is that there was at that time no general law that bound the states. The federal courts could have a view of general law, the states could have a view of general law. They were both looking up at the sky and neither bound the other. Nor was there any federal common law that could bind the states. So if he was intent on binding the states, he had to use due process. He had to put the requirements of personal jurisdiction into due process. Now, Professor Sachs uses this hook that he says, well, look, I mean, once due process requires jurisdiction, you can appeal to the federal court. And then the federal court could reverse the state court on the basis that the federal view of general law was different from the state view of federal law, of general law. Well, there is absolutely no basis for that. Not only couldn't the federal court reverse a state court on a decision made on state law grounds, namely the state view of general law, there would be indeed no appellate jurisdiction. If the state said no jurisdiction, because our view of general law doesn't allow, if the state said there is jurisdiction because our view of general law allows it, there is no federal question. You can't, there is no jurisdiction, appellate jurisdiction. And this is established, as Justice Jackson said, our only power over state judgments is to correct them to the extent that they incorrectly adjudge federal rights. In other words, the court, the Supreme Court, accepts state court decisions of state law as binding. So I think this is where we differ, and I heartily disagree that you have a state case where it decides it has jurisdiction by its definition of personal jurisdiction. And it comes to the federal court can't say to the state, well, look, we got a better view of your state law. We've got a view of general law, and that's binding. Well, it's not binding on the states, but we're going to reverse you anyway. Well, you can't reverse the state for a mistake of state law, because the state law, there is no mistake under state law. They were applying state law. I think there is no doubt that Justice Field in Pennoyer was federalizing this law by putting content into the due process clause, because that's the only way he could federalize. He can't use general law, he can't use federal common law, he had to use constitutional law. And so I don't think that Professor Sachs can, use originalism here to get back to his utopia of general law. He'd have to go back before Pennoyer, sometime between 1868, when the 14th Amendment was adopted, and Pennoyer, when it was decided in 1878. So anyway, in conclusion, what did Pennoyer mean? What Pennoyer did was adopt as general law Huber's view that a sovereign had exclusive power over persons and things within its border. It solidified the tripartite categorization of actions, and it stuck all this into due process. In a sense, Pennoyer is neither right nor wrong. It's the law. If there have been 145 years of allegiance. I think the only pertinent question is how the law could be improved today. I think you can get back to Professor Sachs's view. You could adopt it by saying, no, it's not general law anymore. It is federal common law, and it does bind the states. And you can do that with an originalist view of the Constitution. You could convert a lot of constitutional law into federal common law, binding on the states. This is also what Henry Monahan calls constitutional common law. There is stuff that's binding on the states that isn't in the Constitution. That's federal common law. That's today how we call general law. Indeed, under modern jurisprudence, little to no general law still applies, and we're all positivists today. For my reform, I'd urge the court to push the Constitution into the background. I would prefer a reasonableness test, get rid of the notions of sovereignty in due process. And then I would urge the country to use statutes and treaties to define jurisdictional reach more clearly, acting well within the constitutional bound and building on the EU model of specifying by code the reach that courts have. So under my proposal, the Constitution would indeed recede into the background, much as Professor Sachs would have it. But I don't think that the Constitution should disappear from view. Okay. Whew. Okay. I couldn't see anybody during that whole time. For some reason, my PowerPoint overtook everything. But so it's nice to see you all are still here.
Thank you, Professor. I think we were all hanging on every word. Professor Sachs, response?
Thanks so much. I appreciate the care that Professor Clermont took. I think he has two families of objections. One, that Pennoyer is bad policy, or the model I present is bad policy, and the other that it's wrong as a matter of history. And I want to discuss the second one first. I think part of the problem stems from looking too much at Pennoyer and not at the long sequence of case law from the founding all the way through Pennoyer that is clearly sounding similar themes. This is not something that Justice Field came up with on his own hook in 1878. There are scores of state and federal decisions applying these same factors and talking about the issue as an issue of general law. You can look at Darcy v. Ketchum, you can look at Elliott v. Leslie of Pearsall, you can look at just case after case after case. And I go through this in my paper, Pennoyer Was Right in the Texas Law Review from 2017, if anyone is so interested. in particular on the interpretation of Pennoyer itself. If you look at 95 US at 733, what you see is the claim is that the enforcement of a judgment can be resisted in the state on the ground that proceedings over whom the court has no, of parties over whom the court has no jurisdiction do not constitute due process of law. And when talking about due process, it says a course of legal proceedings, according to rules and principles that have been established in our systems of jurisprudence for the protection and enforcement of private rights. That means subject matter jurisdiction, a tribunal competent by its constitution to pass on the subject matter of the suit. And if that involves merely a determination of the personal liability of the defendant in state service or voluntary appearance. Now, the question is, are those last two things sort of fixed in amber aspects of what due process requires? Or are they field carrying out the substantive implication that due process requires jurisdiction, and here are the things that happen to be required under current law under jurisdiction? Well, if you look at how contemporaries discuss the case, like the Belcher decision the next year, they did not read field as saying that due process hard-coded rules of in-state service and voluntary appearance. They said that due process required jurisdiction as defined under the general law, and the Supreme Court's view of the general law was going to trump. You know, that's not coming from me, that's coming from other contemporary sources. And I talk about some of those in the paper. Now, it's true definitely that in general, a federal court cannot reverse a state court on general law grounds, but it can do so if those general law grounds are relevant to a federal question. So for instance, you would have state courts that would refuse to recognize the judgment of another state, saying you lacked personal jurisdiction under the general law. And then folks would appeal to the federal court saying, hey, if the judgment was valid, then full faith and credit requires its recognition. So federal court, you have to decide this general law issue and reverse the state on the general law issue, because otherwise my federal right is being denied. And the Supreme Court in a bunch of cases in the 1860s actually did that. So it's not that they're generally reviewing whatever the state courts say about general law, but whether burglary has to be at night or something like that. They're saying in a case where a federal question hinges on it, we get to take our own view, just as we would in a diversity case where we're deciding it for the first time. For instance, in Elliott v. Pearsall, which I mentioned before, the state court said, yes, there's jurisdiction. They issue a judgment. There's diversity. So the defendant sues the plaintiff in federal court saying, give me the money back. And the federal court says, yes, you have to do that because applying the general law, we determined that the state court lacked jurisdiction. So I think that there's a big world beyond Pennoyer, which if you look at, you can see why Pennoyer is not some one-off. It is very much embedded in an ongoing tradition. And that's why I argue that Pennoyer was reading that tradition correctly. When you then look at the policy questions that Professor Clermont raises, would this be a good idea? To clarify, I don't think that state legislatures can expand their own jurisdiction because, of course, a state can't expand its borders either. But Congress could, in exercise of its effects power, say, we're going to believe that state if they say they have jurisdiction. So Congress gets that power, if not state legislatures.
Back day.
And as to that, it strikes me that the policy rationales there are pretty good. You know, if you have a situation where Congress is deciding, there's a dispute among different states about who has jurisdiction, Congress is the natural person to answer that question. If you have a question of whether we're stepping on foreign countries' toes, Congress with the foreign affairs power is the natural place to answer that question, not the Supreme Court. And if, for example, we wanted to pass a law that anytime a foreign country would exercise jurisdiction over an American defendant in the same circumstances, we will do the same thing to them. So if France wants to haul our plaintiffs in, we'll haul their plaintiffs in. Under current Supreme Court doctrine, that would violate the 5th and 14th Amendments. Congress could not do that. Whereas I don't see any policy rationale why they shouldn't be able to, but more importantly, it doesn't actually violate the Constitution. And that's what I want to get across. What I care most about is whether Pennoyer is correct as an assessment of constitutional law. And the fact that a reasonableness test, I mean, I'm not sure I want the court doing completely freewheeling reasonableness assessments. But even if that were a good idea, I don't think that's their authority. I don't think they can tell a state, yes, you may exercise jurisdiction because we think it's reasonable. No, you may not exercise jurisdiction if we don't think it's reasonable. They need to be able to say why it violates the 14th Amendment. And that, I think, you can get an explanation from Pennoyer that you can't get elsewhere.
Okay, so let me respond, I guess. The first thing is that I quite agree. I did read the Texas Law Review article, and I quite agree with the description of pre-Pennoyer law. That's why I say your utopia lies before Pennoyer, that this notion that the courts were looking up to the general law to specify what jurisdiction required. That seems very accurate, and that's partly why I stressed Pennoyer in class, is that it was a sea change. It changed everything from a general law approach to a due process approach. Now, it's true that Belcher, didn't seem to quite understand what had happened, but that's a California case. That's not the Supreme Court. And as I say, it's quite amazing the consistency with which courts have looked for the last 145 years at Pennoyer and seen it as reading personal jurisdiction rules into the due process clause. As to the reversal of state law, think of Erie. In Erie, the court could apply federal common law. But if on appeal, if a state case came up to the Supreme Court couldn't reverse the state court on the grounds that, well, we have a different view of the federal common law. The fact is, the federal common law that was applied in Swift applied only in federal court. It didn't apply in state court. And the state could go on doing what it wanted. On the second point, I see what you're saying about the policy. I disagree. I think it's very good that we have the Supreme Court reviewing for reasonableness and basic fairness, and we also that is the law that they can do that. So it's not inventing anything. But the notion, I'm just curious about what you said about the state legislatures. The state legislatures couldn't expand. Well, the state, when they're looking at jurisdiction, are applying according to you, their notion of general law. But general law is subject to legislative change. So if the state says, no, from now on, we can deal with stream of commerce, we don't require anything more than mere awareness or something like that. They pass some law. That would strike me that what's the ground that the legislature couldn't do that? The state legislature is defining the general law for the state. Now, it's under your scheme, somehow miraculously they get to the Supreme Court in a later case. The Supreme Court can suddenly apply its federal general law to reverse. But the state law can stay as it is. And so I don't see why the state legislature wouldn't have plenary authority to rework the state law of jurisdiction. Finito.
If you'd like me to reply, the basic answer is that it's just like a state borders case. So in a state borders case, a state legislature can say, we own New Jersey. And for the purposes of state courts, maybe they have to believe them. Nowadays we'd say, oh, no, it's federal common law. But that's not a thing. Federal common law doesn't exist. It was made up hundreds of years after the founding. What it is general law. And in a federal court case, in a suit between states and the Supreme Court, or in a case involving land grants from different states, if it goes to federal court, the federal court doesn't have to listen to what the state says about a topic that's beyond its jurisdiction. And so a question of state borders is not something that under the general law of conflicts, we will listen to that state as to what it says. We won't trust Montana if they announce we now own New Jersey. We just don't look to their law. And so that's why the federal court has to look to general law directly, not because it is federal law, but because in the absence of any other law that it can look to, it falls back on general law. And that's what the Supreme Court in state borders cases starting in the early 1800s was saying, like Rhode Island v. Massachusetts. Like, look, we just look to all the standard principles of equity and international law and all that stuff, and we figure out where the border is. Likewise, a state would not have the ability to claim jurisdiction in excess of the international law rules about jurisdiction if it doesn't have authority over the defendant already, such as through citizenship. So the reason why a state can't claim authority over an out-of-state citizen who doesn't have, isn't served with process and so on, is that we, the federal courts, would not recognize such an assertion of authority.
I agree entirely. The state can't define its own borders and it can't define its own jurisdiction. But that's because the federal law actually applies within the state, either as federal common law or as a constitutional matter. That I think that your assertion that the state legislature couldn't do this unravels the whole argument, so that the federal law is applying within the state.
Well, I'll just note that pre-14th Amendment, when there was no claim that there was any federal law on the topic whatsoever, federal courts would say, no, sorry, the state legislature, you can't do that. And so, and the way they explained it was general law.
Right.
So I'm enclosing a link in the chat to the article if anyone is curious.
Okay.
Thank you, professors. Do we have any questions from the audience? If not, I'm sure that I can provide plenty. However, want to give some other people the first crack at it. So you can go ahead and raise your hand, or if you'd like, you can type it into the chat. Michelle, you got your hands up. You get to be the first one.
Oh, yay. I guess my question is, and just you guys have kind of touched on it, but I like elaborate a little more. All, the talk about federal general common law and general law really, and Erie was reminding me of Erie. And I am not, see, the goal of Erie, if I remember correctly from 1L year, was that there isn't one general law that the federal government can apply and enforce on the states. They instead have to defer to state courts unless it's specifically federal common law in specific, very narrowly defined areas, or it's a constitutional matter. So I'm just a little confused, Professor Sachs, because it seems like your conclusion sort of violates the spirit of that by saying, no, there is a general law which the federal courts are interpreting and applying, which seems to go against Erie.
So first, I'd say it doesn't just violate the spirit of that, it stomps it into the dust as far as humanly possible. Erie is wrong. I've just put a link in the chat to explain why. But the key issue here is not that there is some general common law that federal courts can just go and enforce and impose on the states whenever they want. I think that part of Erie is correct, but I think Justice Story and Swift v. Tyson would have agreed with that too. It's not that general law is always superimposed on state law. It's not that it outranks state law. It's that sometimes when the states incorporate general law by reference, or when the federal courts can't use state law for one reason or another, they have to use general law instead. They have to use whatever they can. And so this is a case, the state borders situation is think about that model. Nowadays, we call state borders law federal common law. That's the way the Supreme Court talks about it. But nobody talked about it that way for the first 100 years of the Republic. Instead, what they said was, look, we can't look to state legislatures here because their law, the first place we have to look is for choice of law rules. If Nebraska and Kansas claim the same territory, whose law applies? As a choice of law matter, we start off with general law choice of law rules because that's the only thing we can use. We don't have choice of law rules from Congress. We just have to use them from general law. And we can't trust either state to tell us. And then when we're using that, well, think of the Rules of Decisions Act. We use state law in cases where they apply. Well, when do they apply? That's a general law question unless Congress has specified it. And so the reason we don't look to either Nebraska or Kansas in figuring out where the border is because as a general law matter, neither state's law controls that question. Whereas if you were asking me the question in a diversity case, there's some, property dispute in Nebraska, well, general law would say that's a Nebraska law question. So we have to look to what Nebraska says, whether it's by statute or by common law or whatever it is. The problem with Erie is twofold. One, that it claimed that all state common law and all state references to general law were really delegations to state courts to make something up. Which I think is not the way state constitutions have to be interpreted. But secondly, that it claimed that general law in this context doesn't really exist. And I think that's just a jurisprudential error. I mean, that's just a philosophical mistake by Holmes and company. And you can read in the article I put in the chat as to why.
Thank you.
Professor Clermont, do you want to comment on that one too, or do you want to go to the next question?
Well, I mean, it was a good question, and I think I would view general law as extinct. That's what I mean. We're all positives now that the law has to come from somewhere, and it's going to come from the state or from the federal government. And basically, our point of difference is that I say that the law of territory, the outer limits of territorial jurisdiction come from federal law. I think from the Due Process Clause, thanks to Justice Field in Pennoyer, but I'm perfectly willing to go along with Professor Sachs and say, no, now it's federal common law. And so all of his advantages could be achieved then. If he just calls this federal common law. It is, however, binding on the states. It would be manipulable by Congress and everything else, all the other good things he wants. But he seems to be determined to say, no, that's not federal law. The states can have their own general law, but we're going to reverse them as soon as they show up in federal court. Surprise, you're applying state law, but we're going to reverse you, which isn't authorized by the Constitution or anything else. Federal courts can't decide matters of state law.
Thank you, Professor. And I have a question that's kind of on that point about the appellate jurisdiction. What if, as I understand Professor Sachs's argument, it's that due process of law means you have to have jurisdiction, and jurisdiction is a matter of general law. So why wouldn't that then be a question of federal law incorporating state law, thus creating federal jurisdiction in the same vein as like Indiana ex rel Anderson versus Brand, or maybe more recently Cruz versus Arizona?
So the Due Process Clause says you have to have jurisdiction. It doesn't say you have to have jurisdiction from general law. And I should say says, sort of it entails, what the courts were saying in cases like York v. Texas is that it's the deprivation of property without a lawful judgment that creates the due process problem, because you need a lawful judgment to explain how this property was taken away with due process. So it's not that the Due Process Clause specifies general law. It just says you need to have something. You need to have jurisdiction. You need to have authority. And it so happens that the only recognized sources of authority at the time were general law, but that's why Congress might, within its enumerated powers, supply other explanations for why we should find authority here, even if general law would not. So it's the claim is not that the general law is sort of fixed in constitutional amber, or indeed that sort of state law gets to control. The claim is just, look, you need to have some jurisdiction in the eyes of the federal court. When will the federal court think you have jurisdiction? Either when you're playing by the general international rules or when Congress says so. And those are the circumstances in which the federal court will say, yes, I see jurisdiction here. And if they don't see jurisdiction here, then they're going to reverse the state court.
I'm starting to think now that our central disagreement is that Professor Sachs views this as an ongoing question of state law, which miraculously can get reversed if it happens to wander in on an appeal to a federal court. And I, on the other hand, am saying is no, there is federal law on territorial jurisdiction that applies within the state, that the state has got to follow it. So we're not reversing it because our view of general law differs from the state view. We're reversing it because the state failed to apply the federal law that was applicable within the state.
So actually, if I could go a little further, I think our fundamental disagreement is that, if I'm not putting words in your mouth.
No,
that,
I'm sure you're not.
In your eyes, general law is always either state law or federal law.
Today.
And in my view, that is not the case. In my view, general law is neither state law nor federal law, though either the state or the federal government could incorporate it as their own law if they wanted to.
I agree. That's an alternative way to state what I just said too. Yeah.
And that's why in a lot of ways, the argument comes down to Erie. You know, if one thinks that Erie is correct, then the model of general law is just got to be either state or federal. There's no third box. Makes a lot of sense. If one thinks that Erie is wrong, then the possibility of a third box seems very plausible.
Yes, I think Erie was right. So, yes.
Perhaps in the future, we'll have to have an event on whether Erie was right.
I'd look forward to it.
Delighted to have you back, Professor Sachs and Professor Clermont. Professor Sachs, you mentioned jurisdiction based on the federal question of the full faith and credit clause. Why would that create appellate jurisdiction rather than merely jurisdiction in the collateral attack that would have happened either under the old system or still sometimes happens today?
So there are a few cases in the 1860s where you had a state court that said, you had F1 was a state court. So some state court rendered a decision. In F2, some different state court said, no, we won't recognize F1's judgment. And then the losing party, who was the winner of the first judgment, would appeal to the Supreme Court and say, hey, I have a federal right under the full faith and credit clause to the enforcement of my judgment in F2. And they denied it. And so under Section 25 of the Judiciary Act, I can come in and ask for federal review. And in substance, what the court was deciding there was the general law question of whether F1 had jurisdiction or not. But in form, it was deciding whether F2 had denied effect to a judgment contrary to the full faith and credit clause.
And I would say that that full faith and credit question is defined by federal law, that the idea that you apply the respect that the rendering court would give is a matter of federal law. And so it's a smoother path into the court, into the appellate court.
Yeah, I mean, I think this is fundamentally our labeling disagreement, because if you look at what Darcy v. Ketchum says, you know, it says it's talking about the international law between the states as it existed in 1790 and so on. So the question is that federal common law? You know, it's not necessarily how they would have thought about it. But
no, they certainly wouldn't. I mean, we can't have a disagreement in the 1860s. I'm with you for the first 100 years, but jurisprudence has moved on, and so general law, I think, is just sort of died off. It could be that the state could still insist that it's general, they're applying general law, but in the federal courts, it seems that there are only two boxes, federal law and state law.
Anybody else has any questions? I don't want to keep popping in with mine, but I do have lots of them. So Professor Sachs, in that hypothetical you described where F2 denies recognition to F1's judgment, and then they appeal that up, that's an appeal, excuse me, an appeal of the collateral attack. How would you get jurisdiction on direct appeal in, not in F1, but of F1's judgment before opening the separate suit? Would there be
pre-14th Amendment? You couldn't. Pre-14th Amendment, there would be no argument that F1 had violated any federal right because this wasn't federal law, this was general law. What the 14th Amendment does is say, if you're going to execute this judgment and take actual property away, then you've got a due process problem. And that's a reason not to issue the judgment in the first place. You shouldn't issue a judgment that would violate the Constitution to execute. And so therefore, not only can you make that argument in the state court, you can also go to the Supreme Court and say, hey, this judgment should be reversed on direct review.
I think that the federal law there did apply under the Act of 1790. The Full Faith and Credit Act did make it applicable in federal law, applicable in state court. Any court in the United States must accord to another state full faith and credit.
Right, that's in F2. So in F2, with a state judgment from F1 in hand,
Right,
would then
right.
be on that.
I
So
thought we were worried about whether F2 had to respect F1's judgment.
Right. I'm sorry. I understood the question as sort of, was there a route to appeal from F1?
But F1 hadn't done anything yet. What? I thought you were talking about the F2 denying full faith and credit. Well, okay. We've killed off Ithaca's interest in Pennoyer.
I think probably the last question we have time for, unless anybody wants to jump in and throw their hand up before me, is how does this play out under either of your views? How does this play out in Mallory?
So I have an amicus brief in Mallory in which I argue that Pennsylvania does have jurisdiction here, or if not, it would be a dormant commerce problem, not a due process problem. So in Mallory, for those who might not be completely up to date, here's a case where a Virginia railroad is sued for conduct in Virginia by a former employee who is now retired to Pennsylvania. And the railroad does business in Pennsylvania, but none of that had anything to do with the employee's claim. So there's no claim of specific jurisdiction based on Pennsylvania stuff. Instead, the argument is that the Pennsylvania courts have jurisdiction because the railroad had obtained a license to do business in Pennsylvania, which required, among other things, consent to the general jurisdiction of Pennsylvania courts. This was completely standard pre-14th Amendment and post. This sort of, there was dispute about how far a state could exercise jurisdiction if it did not obtain a license, if it didn't sort of write it out. But if it did actually formally agree, then you could definitely subject it to jurisdiction. There's, Harvard Law Review articles from the 1890s talking about this. And the arguments before the court are really about whether Daimler and other post-international shoe cases have done anything to this. And in my view, this is setting sort of my own views of how, Pennoyer works and so on aside. In my view, the post-international shoe jurisprudence really doesn't do anything to this, and it really is a question in due process, in dormant commerce rather, because the issue to my mind is not whether a corporation can consent to personal jurisdiction. I mean, surely the answer is yes. Surely if the state announced, we will give this nice shiny nickel to anyone who agrees to our general jurisdiction, a corporation could totally say, yes, we'll take that deal. I don't see any constitutional reason why they would be forbidden from doing so. The real question is, what inducements is a state allowed or forbidden to offer? What can a state say? If you don't agree, we will do X, Y, Z. And that really is an unconstitutional conditions argument, and to some extent a dormant commerce argument, to the extent that the claim is that a state must allow in foreign corporations. Now, I think as a dormant commerce argument, that's crazy. If you look at the founding, it was very clear that states did not have to let in foreign corporations. They had a Commerce Clause then too. So I don't see any good originalist argument for why a state is prohibited from restricting entry of foreign corporations or conditioning it on various grounds. But if one thinks that there is such a dormant commerce protection, then that, to my mind, is the relevant barrier to Pennsylvania exacting that kind of consent. And moreover, it's important which clause it is, because if it's a dormant commerce issue, then again, Congress gets the final say. Congress could say, oh yeah, that's fine. You know, Pennsylvania gets to do this. Or it could say, no, you can't. And so to the extent that the courts have to figure out what to do in the meantime, they can do their pike balancing or whatever they have to do. But there would be no sort of made up constitutional bar to Congress saying, yes, we're going to allow suits by Pennsylvania citizens, as a condition of operating in Pennsylvania. We choose to allow that as a criterion. I don't see any constitutional reason why Congress couldn't come to that decision.
Now I don't know how you could get Pennoyer so wrong, because I agree completely with that analysis. I thought you explained it incredibly well. So unfortunately, I'm not sure that the Supreme Court will agree with you.
I have no expectation of that.
Yeah, they seem hell bent here on reversing. But the interesting thing is that the Pennsylvania law is not quite as explicit as you phrased it. I mean, if it were that way, I mean, the analysis would be good. The Pennsylvania law strangely says in its corporation statutes, hey, you got to register for doing, if you do business in Pennsylvania, period. And then in the jurisdictional statute, there's a listing of various things under the long arm. One is if you registered, you're subject to general jurisdiction. There's no linkage between the two. And apparently Pennsylvania is the only state in the country that has this kind of a statutory setup. A lot of states have, if you register, you're consenting statutes, but that's not Pennsylvania. So I think I wouldn't be surprised if this thing is dismissed as improvidently granted, because this was a stupid statute to pose the general question on.
All right, thank you both so much. I'm going to turn it over to Nitin, who has a couple of closing announcements for us. But thank you, Professors Sachs and Clermont. I have really enjoyed this event, and I hope that everyone else did too.
Thank you.
Thank you so much for coming tonight, everyone. And in particular, thank you to Professor Sachs and Professor Clermont. We're really honored to have hosted you both. So thank you very much for sharing your time with us. Before everyone goes, I do want to plug our next two events. So this Thursday at 5:30, we're hosting Professor Daniel Lyons and Professor Manahan for a discussion on Section 230. And then next week on Monday at 6 p.m., we're hosting Professor Christopher Walker and Professor Stiglitz for a panel discussion on the major questions doctrine, Chevron deference, and the future of admin law. It's been nice seeing so many new faces tonight, and we hope to see you at all our upcoming programming. Have a good night, everyone.